Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Mark Erickson, and Mark is a family law attorney. His firm is located in Campbell, California. Mark graduated with a JD or law degree from Santa Clara University School of Law in 1979. He was admitted to the California State Bar and U.S. District Court, Northern District of California in 1979. After working for another attorney, mostly in the areas of civil and business litigation from 1979 through 1984, he founded his law firm in 1985. He became a certified family law specialist by the Board of Legal Specialization of the State Bar of California in 1987. He has lectured and presented seminars by many groups, including as a teaching assistant and guest lecturer at the Santa Clara University School of Law. And Mark has two adult sons, and one of his sons is also a lawyer and has been working with Mark for 4 years. So, congratulations with that, Mark. And I have a number of past episodes with Mark about divorce-related topics. Those are posted under past episodes on our website, financialinsiderweekly.com. Today, Mark and I are going to be talking about spousal support relating to divorce in California. And this is a complex area of law for which you should consult your own attorney. And also, divorce laws vary among the states. So we get viewers for our show from various places, but you really do need to get your own attorney, and we would encourage you to do that, but maybe this will help to stimulate your thinking. Mark, thanks again for joining me.
Thank you. Glad to be here.
Okay. So what is a definition of spousal support?
Okay. Traditionally, I think people have called it alimony.
Yes.
And in many parts of the country, I think that's what they call it, alimony or separate maintenance. Mm-hmm. California, we call it spousal support, and it's a payment made from either a current spouse or former spouse pursuant to a court order as part of a dissolution of marriage proceeding or in post-dissolution of marriage proceedings. It's usually a specific amount paid monthly, often once or perhaps half on the 1st and half on the 15th of each month, sometimes for a specific term or sometimes open-ended without any specific termination date.
Okay. So how has spousal support changed over the years?
Well, in my practice, one of the things that I've noticed that has really changed is maybe some gender issues. When I started 36 years ago, I did not see any cases for many years where the woman, the mother or wife, was the payor. Mm-hmm. And as opposed to today, I'm seeing it's very common, particularly with younger women. Younger women are very often the high earners, or maybe the only earner, and there's no gender preferences when it comes to spousal support. Whoever is the higher earner is likely to be the payor. Mm-hmm. And I still haven't seen it in any of my older clients, although I think I've finally had a case where a woman in her 50s was paying spousal support, but with women in their 30s, in my practice, I'd say it's almost equal now in terms of who the payor is, at least in the short term.
Mm-hmm. Okay. How about the same-sex marriage thing?
Same rules. So the same rules are going to apply, and the same standards, which generally are need an ability to pay, as well as other factors in the code that the court must consider in making a spousal support order, and we'll get into what those factors are.
Okay. And related to that, a marriage as opposed to a registered domestic partner, is it basically the same thing?
Yes.
Okay. So how do you apply for spousal support?
Well, initially, let's just have a little fact pattern here. People are married, a divorce starts, somebody moves out of the house, and I'll say the non-earner or lower earner, the more dependent on the other spouse financially, would make a request to court by filing what's called a request for order, asking the court to set a hearing and determine spousal support. Now, most spousal support orders are negotiated, but ultimately, if you're not able to reach an agreement, the court's there to make a decision. In the short term, all the courts in California will follow some sort of a schedule. Santa Clara County has its own formula for determining spousal support, and it's built into a computerized program. There are a number of programs approved by the state for calculating child support, and all of those programs will also have the various spousal support programs from different counties using their formulas. But it's primarily a function of how much income each parent has. If there are children, that would certainly go into the equation too. Tax factors as well as filing status. Are the parties going to be filing jointly or separately? Are there children so that one or both of them might qualify for head of household status? And then there's some other tax factors such as deductible mortgage interest. If one parent's paying that, that would go into their column, as well as deductible property taxes if there's a residence that they own. And other income other than employment income would go in, some of which might be divided equally if it's community property. So it can get complicated putting the entries in. There can be adjustments to income for contributions to 401k plans, and certainly different types of income might be taxed differently. Say, for example, self-employment income would go in as a separate entry because of the requirement to pay the self-employment taxes, which are higher than if you're a W-2 employee. So it can be complicated sometimes determining what the inputs will be into that formula, but most people, because you know that the court is in all likelihood going to follow that formula to determine temporary support, people are able to reach an agreement, perhaps reluctantly, and the payor usually thinks it's too high and the recipient thinks it's too low, but it usually results in an agreement, at least at the outset. That's the easy part, temporary support. The harder part is permanent or judgment support, which would be at the end of the case. So when you get your judgment to determine the final orders, what is the support order going to be? And when you get to that point, the court cannot merely look at this formula and plug the information into the computerized program and push the button to come up with the answer. The court must consider factors in a family code section that starts out with age of the parties, health of the parties, length of the marriage, whether somebody stayed out of the workforce during the marriage to raise minor children, property holdings. Does one spouse or the other have separate property that the other one might not have? And then there's some catch-alls. Anything else the court believes is relevant, and the court must consider a documented history of domestic violence. And then there are a few statutes that tell the court what it must or must not do, or may raise some presumptions. So it can be a complicated decision, and because the court has to weigh all these factors, the judge has discretion, as opposed to, in the short term, just applying that formula. When it comes to permanent support, the court has to weigh their judgment. And I've always say that if you had 100 different judges, they might come up with 100 different support orders that are all within their discretion.
So the temporary is before the divorce is final, and then the permanent is what's going to be in place after the divorce is final?
Generally, yes. So it's possible to have what you call a bifurcated order, where spousal support might be decided either before or after the other financial issues and be in a separate order or judgment.
Okay. So how long do you usually see this temporary spousal support program last?
Well, those orders can be all over the place. Sometimes it's a matter of months, and sometimes in a very short marriage, you might just agree that the temporary support order is the final order and agree to a short-term spousal support order. Mm-hmm. I've seen temporary orders last in excess of 15 years, where for whatever reason the folks were not able.
Can't come to a conclusion.
Couldn't come to a conclusion. In these long-term orders, it's probably usually by choice because the parties don't want to end it for various reasons. There may be complicated assets, there may be business assets, other collateral issues. But I would say typically 6 months to 18 months would be a common time frame for a temporary order. Mm-hmm. And in the duration of a permanent order, again, the court's going to weigh all those factors, and if it's a long-term marriage defined as in excess of 10 years, the court likely will not set a termination date, at least at the outset, unless there's evidence that the supported spouse will be self-supporting by that date. Mm-hmm. So it's very difficult to predict, particularly if there's a long marriage, how long is that order going to last.
Okay. Are there separate judgments for terminating terminating the marriage and for financial issues like spousal support and dividing the property?
Yes, and I mentioned that concept of bifurcation, where you could have multiple judgments. Sometimes one spouse or both of them want to terminate their marital status early on, perhaps for tax reasons or other reasons. And so after 6 months has elapsed from the time the respondent is served with a petition for dissolution of marriage, on request, the court can terminate status after 6 months. Sometimes some of the financial issues are resolved early on. I always say, in theory, your divorce could be over the day you file it. Not likely with all the paperwork and disclosures that need to be done, but at least in theory it can be done very quickly, or at least some judgments could be done quickly. Spousal support, I'd say, tends to be one of the last issues to be resolved and one of the more difficult issues to resolve, particularly after a long marriage, because you often don't know what the supported spouse is going to do with their life in terms of their career or going back to work. And that's often a big issue, and after a long marriage, particularly someone that might need education or training, or if there are special needs for children, you might give them some more time than, say, someone after a short marriage with no children would be given to get back into the workforce.
Okay. When a divorced person remarries, how do new spouses tend to respond to spousal support obligations? Okay, so in other words, somebody that's already got this obligation to pay spousal support, and now they're marrying somebody new.
Sure. So we're talking about the payor of spousal support getting remarried.
Yeah, and how does that person respond to this?
But probably they're not happy about it,
right.
and certainly over the years I've seen that's sometimes what's precipitated a consultation with an attorney to find out, can I reduce it or terminate it? Sometimes when a couple comes into my office, I'm not quite sure which one is the client, but sometimes it's the new spouse or boyfriend or girlfriend bringing in their significant other, suggesting that they might be able to modify or terminate a support obligation they have. Or, if they're not married, increase the amount of support they're already receiving. And then, of course, for the recipient spouse, if they remarry, the law is that spousal support terminates automatically on remarriage.
Okay. What about death? Does that terminate the obligation for spousal support?
Yes, by operation of law, and it's also important that when you draft a spousal support order, that it specifically states that the spousal support terminates on the death of the recipient. That's a requirement in the Internal Revenue Code for the spousal support to be tax deductible to the payor.
Okay. So what about the payor spouse? What if they pass away? Does that obligation stay there?
I've seen people fight about that. Typically, an order I draft is going to say that it will terminate on the death of either spouse. So that would be a common provision, although you certainly could specifically have it continue after the death of the payor. More likely what you see is a provision for life insurance, so that if the payor passes away, there was an obligation for the payor to provide life insurance to at least give the supported spouse what they might have expected had the payor survived for at least the expected life of the spousal support order.
Okay. Does anything happen when the recipient spouses remarries versus cohabits? So in other words, if they don't marry somebody but they move in, is that different?
You see a lot of disputes and a lot of discovery done in dissolution cases or post-dissolution to try and determine whether the recipient is cohabitating. The reason is the law says that there is a presumption of decreased need for spousal support when someone is cohabiting. Used to say with a member of the opposite sex, and I think that's changed recently.
I guess so.
And so cohabitation is difficult to prove, and I think it's common that recipients of support will deliberately not remarry as long as they're getting a good spousal support order. Although they may have a new relationship, they will either see that it doesn't go over the line, wherever that line is, from a boyfriend or girlfriend to cohabitation, or if they truly are cohabiting, some people try and hide it, and it's difficult to prove. It's one of those
cohabiting,
areas.
but he's just my roommate.
That's right. Or they just stay over occasionally.
Okay, and that makes work for private investigators, I guess.
It does. It makes work for private investigators, lawyers, court reporters, and judges.
Oh boy. Can the roles of the provider and the recipient change?
Absolutely. Spousal support orders, temporary or permanent, are modifiable based on a showing of changed circumstances. So it would not be uncommon in a support judgment to say the husband's order to pay his wife $5,000 a month spousal support until death or remarriage or further order of court, and jurisdiction is retained for the payor. Well, now it's 5 years later, and say the payor has lost his job, can't find a new job, maybe his job is obsolete because of whatever it was he was doing, and now the former spouse is very successful and has a high income. It certainly would be possible for the former payor to request support from the former recipient.
Oh boy. Are there substitutes for support?
There can be. Certainly in any issue in a dissolution of marriage case, people can negotiate whatever settlement they want, and the court will approve it. And spousal support is certainly one where you sometimes see creative resolutions, which could be giving someone more property. And so they may say, I'll drop that issue where I'm claiming the family residence is all or part my separate property if you will either take less support or no support. Or we'll see buyouts where you may do an estimate of how long you think support would last at a particular amount, reduce it to present value, and then perhaps reduce it again for because of tax deductibility, and then pay a non-tax deductible lump sum in return for a waiver to ever seek support in the future and a termination of the court's jurisdiction over that issue. That can be easy to do in a short-term marriage where you're not dealing with a huge income disparity, but it can be difficult when you have a long-term marriage and you have a very high earner and a very low or no earner. Trying to come up with a lump sum is difficult. The other thing people will do as a substitute for the way a court might order support is agree to a fixed non-modifiable. So even though the law says support is non-modifiable, you can reach an agreement to make it non-modifiable, and you could make it for a specific duration, or it can be non-modifiable for a particular time frame, and then be open-ended after that. So there's almost anything you could imagine can occur in a negotiated spousal support order, and part of that is because it is a discretionary issue with the court. It's often unpredictable what the result would be, which leaves a lot of room for negotiation between parties.
You talked a little bit about this role of life insurance. Did you have any other thoughts related to that you wanted to throw out? Or
I would just say that it's common, and I think the common order would be for the payor to provide it at their expense, and then often a declining balance as you see the spousal support perhaps going down in the future. But if I represent the recipient, sometimes I would prefer that they own the policy and they pay it, so they make sure it occurs. Because it'd be a shame if your spouse was required to provide it, they pass away, they didn't pay the premiums, you find out the policy is lapsed, and there's no other assets from which to enforce the obligation.
So something that I don't really have a question about, that we've discussed before, but what about the problem of collecting spousal support?
Well, there are, like any judgment, they are not all self-enforcing. You can have a wage assignment, so if your spouse is a W-2 employee, the employer can be served with a wage assignment, so you collect the money directly from the employer. Now that can be difficult because some orders are variable, and what I mean by that is particularly here in Silicon Valley, we have a lot of people who have stock options or restricted stock units, employee stock purchase plans, or other benefits that are part of their compensation package, but it isn't a set amount each and every month. Mm-hmm. And so we'll have a court order that is set on a base level support. So say the employee makes $20,000 a month salary, we'll set support based on that, but if and when they get a bonus or income from stock options or RSUs or some other source, they're required to report it and pay a percentage of that income if and when received. You just can't prepare a wage assignment that effectively deals with those issues, particularly since usually these percentages that are paid as additional support are floating percentages based on a chart, and it varies with different incomes of income because of the tax consequences of different levels of income.
Uh-huh. Now, I've seen some things as a tax return preparer and so forth, that California is actually requiring employers now to report when they hire somebody. I mean, this has been going on for a while, and my understanding is that this relates to collecting spousal support,
yeah,
or maybe for the child support.
Probably primarily child support,
yeah,
through the Department of Child Support Services.
Yeah.
But certainly, when we negotiate orders, we often will put in provisions that require both parents or both parties to report future employment, any change in employment, and to provide a copy of their employment contract or description of their benefits. Sometimes there are requirements to annually exchange tax returns so you can see the other party's income and either verify that they've paid what they're supposed to pay, or determine whether there's a basis for modification of the support order.
Right. Well, we have a couple minutes left. Do you have a final thought that you want to throw out?
Yeah, I think one of the most difficult issues is the question of the unemployed or lesser employed spouse and what their obligation is. And the law says in most cases the court's going to give what they call a Gavron warning, telling that spouse that they have an obligation to try to become self-supporting, and if they don't, that's a consideration the court can look at in determining whether to decrease or perhaps terminate support in the future. So we see a lot of conflict over the recipient's ability to earn, which often involves retaining expert witnesses to evaluate them based on their background, education, and experience to determine how much should they make, what should they do, and how quickly should they work towards self-sufficiency.
Uh-huh. Okay, well, I want to thank you, Mark, for joining me today.
Thank you.
I think that, again, we've provided some very valuable information to our viewers in our series of interviews on divorce-related issues. And, you know, it's a very difficult life experience to go through. I mean, we could just go talk about the emotional issues maybe someday, but really maybe it would be more fitting for a psychologist. Anyway, but anyway, I want to thank you for bringing your experience to us. And so, folks, I hope that you found this valuable. And if you have somebody that's going through this experience, again, we're going to have this posted on the internet at our website, financialinsiderweekly.com, so you might tell them about it. See you next time on Financial Insider Weekly.